Today, we will talk about how to sue Child Protective Services. Let's have a look at the details. Each state has its own Child Protective Services (CPS) agency that is responsible for protecting the health and welfare of children. CPS investigations can be traumatic and stressful for both parents and children. However, emotional distress alone does not give you the right to sue CPS. Since CPS social workers are government agents, they cannot act in ways that violate your established civil rights. An overzealous CPS worker may violate your constitutional right to due process, or your protection from unreasonable search and seizure. When that happens, you may be able to sue for monetary damages. The first step is building a case. Create a chronological outline of events. Beginning with your first encounter with CPS, draft an account of each encounter or communication you've had with CPS social workers and other staff members. Gather any related documents and other evidence. You should already have been documenting every interaction you had with CPS. All of these records are now evidence you can use in your lawsuit. Consult an attorney. Civil rights lawsuits in federal court are notoriously complicated. If you've decided to sue CPS for violating your constitutional rights, you need an experienced civil rights attorney to represent you. Identify an established right. Your attorney will review your documents and notes to determine which of your civil rights have been violated in your situation. Calculate your damages. The amount of money must be directly related to the violation of your rights. The second step is initiating a lawsuit. File a complaint. A complaint in federal court that alleges violations of civil rights requires more information than the typical complaint. If the violations aren't explained correctly, the lawsuit may be thrown out. This is why you need an experienced civil rights attorney. Has CPS served with the complaint? Once your complaint is filed, CPS must be notified of the lawsuit so that it has the opportunity to respond. Your attorney typically will have the complaint served on the attorneys of record for CPS. Evaluate the response from CPS. When CPS is served with your complaint, the agency has a limited period of time to file an answer with the court. A copy of that written answer will be delivered to your attorney. Attend the summary judgment hearing. And, the third step is going to trial. Send written questions and requests to CPS. You will work with your attorney to create written questions and requests for documents, which must be answered by CPS. Depose the social workers involved. A deposition is an interview under oath. Since so much of your case relies on the subjective beliefs and interpretations of the social workers involved, these depositions will be crucial. Prepare for your own deposition. The attorneys for CPS will likely want to depose you as well. Your attorney will meet with you at least once to go over likely questions you'll be asked and explain to you how to respond to deposition questions. Answer questions from CPS. Just as you sent written questions to CPS, the agency will likely send written questions for you to answer as well. Your attorney will draft the specific answers after consultation with you. Participate in pre-trial hearings. Judges typically schedule numerous hearings to make sure the litigation is on track and progressing on schedule. You won't have to attend many of these hearings or meetings personally. Your attorney will update you on what happened. Evaluate any settlement offers. Lawsuits in federal court seldom make it to trial. Discovery can drag on for months, and most litigants prefer settling the case to avoid the uncertainty of trial. The judge may encourage settlement talks or preside over a settlement conference. Thanks for watching this video. Please don't forget to like and subscribe to our channel if you like our videos.